Good afternoon, and thank you very much for joining the latest in the Trinity Talk sessions. Last week, we hopped across the channel to our Paris colleagues for an examination of the current trends in Francophone markets in Africa. Today, we're back in London, and we're looking at force majeure in construction contracts. As a firm, we've seen increasing numbers of claims and queries, both potential and actual, relating to force majeure from our various clients. This is particularly the case for IPPs in sub-Saharan Africa. It seems that the COVID-19 pandemic has really begun to test the force majeure provisions in various industry contracts, and the construction industry is no exception to this. So today, my colleagues, Luke Muchmore, a partner in our London office, and Harvinder Diol, a counsel in our London office, will discuss force majeure claims in the context of construction contracts, with a focus on FIDIC-based contracts in particular. So I will now hand over to Harvinder.
Thank you, Fiona. As Fiona mentioned, in this talk we're going to focus on FM claims in the context of construction contracts with a focus on FIDIC-based contracts in particular. However, it's difficult to have a discussion on such a topic without referring to some of the wider contractual and commercial issues that are inherent in FM situations, and hence we will be touching upon some of these wider issues during the course of this Trinity Talk session. If there's just one point from this talk that we would ask you to take away and remember in the context of FM, then it would simply be to remember to read your contract. Now, this may sound like a very obvious point, but it's important to remember in the context of the fact that there is no single standard FM clause in construction contracts, and the language differs between standard forms and bespoke contracts. Therefore, each event of FM and the associated FM clause must be carefully considered in its contractual context to determine how it operates and what relief is actually available. Given the relative infrequency, at least in previous years, with which FM mechanics in construction contracts have been used, it's understandable that certain assumptions or misconceptions have built up around the concept of force majeure. We found in our practice that it's often tempting for stakeholders to apply an instinctive method to their analysis of whether an event constitutes force majeure and the relief they believe is available. Examples that we've seen can include where terrorist attacks have occurred, or more recently, measures have been taken in an epidemic that affected a contractor's ability to enter a site. These events often have the feel of an FM event, but it's not always a given that it will be, contractually speaking, and hence the mantra of why it's important to read your contracts. In contracts that are English law governed, it's vital to remember that there is no principle or overarching principle of force majeure enshrined in English law. The definition of force majeure, and more importantly the consequence, at least in contractual terms of an FM occurring, is a matter to be freely negotiated and agreed between parties. The case can be somewhat different in civil law jurisdictions. In those jurisdictions, FM is generally codified, and it normally has to satisfy three broad requirements to meet the test for FM. A high-level example can be the event must be beyond the party's control, it has to be unforeseeable, and it's unavoidable by the use of appropriate measures. Care needs to be taken in these jurisdictions. They sometimes legislate that even if performance is possible, albeit costly, then it's unlikely to qualify as FM. However, codification of force majeure can assist where the contract is silent on an FM or an aspect of FM. In general, in those jurisdictions where a contract contains FM provisions and FM is codified in law, then the contractual provision acts to supplement the law unless otherwise provided by the parties. So next slide. As a matter of drafting convention and contractual interpretation, a typical force majeure clause event, a typical force majeure clause broadly refers to an FM event being firstly beyond the control of the parties, which secondly frustrates or delays the performance of a contractual obligation to the extent that the obligation cannot be performed or is subject to a significant delay. Many of the construction contracts adopted in the IPP market, particularly in sub-Saharan Africa, where the majority of claims we have been reviewing originate from, are turnkey EPC contracts. Such contracts have adopted the standard form issued by FIDIC entitled the EPC Turnkey Projects Conditions of Contract, which is colloquially known as the Silver Book. The majority of these contracts have adopted the first edition of the Silver Book, issued in 1999, albeit that a second edition was also issued in late 2017. The FM provisions in both the first and second edition are broadly similar, but for the purpose of this discussion, we will not enter into greater detail about the differences between the two editions, either regarding the claims procedure, etc. But for a more detailed discussion on these points, please visit our website or contact Luke or myself and we can discuss this in further detail. Irrespective of whether the first or second edition of the Silver Book is used, invariably the FM clauses of such contracts are often amended by the contracting parties. This will almost definitely be the case where the contract is used in the context of an IPP, because it will need to be adapted to match the FM clause in a third-party contract entered into between the employer and a sponsoring entity or government. And here we're talking about agreements such as the implementation agreement, concession agreement, or power purchase agreement, or the like. We'll come back to this a little later in more detail. Needless to say, there's no one-size-fits-all approach here, and this brings us neatly around to our mantra of read your contract. It's ill-advised to assume that the FM clause in a construction contract, even one based on a long-standing standard form like FIDIC, covers the eventuality we're focused on. It's a question of revisiting the detail. Again, there's a strong likelihood that it may have been amended, adapted, such that there's got caveats and limitations. So when looking at reviewing an FM clause and FM claim, it's important to adopt a methodical approach to analysis of the provisions, given what we have said before regarding assumptions around how FM works or may work. We've approached our review of claims and clauses with a series of high-level questions, and these are set out on the slide. Taking each one in turn, what particular events have the parties agreed constitute FM? It's important when looking at the test of FM whether it's actually defined by a general test or whether the FM events have been described in an exhaustive or possibly non-exhaustive list, or commonly a combination of both. It's also worth checking if there's a catch-all provision that tries to describe FM events by analogy, where they're not being specifically listed out. To give a solid example of this, let's take the Silver Book, which actually gives a 4-point test, whereby an FM event needs to be beyond the reasonable control of the parties could not have provided against it, parties could not have recently overcome it, and the event is not actually attributable to either party. The next point is to examine whether the FM event is a political type event or a natural type event. Again, using FIDIC as an example, the drafting goes on to mention events falling into two broad categories. Political events are those such as war, insurrection, sabotage and terrorism, whereas natural are, as the title suggests, natural catastrophes such as earthquake, hurricane, volcanic activity. So it raises the question, well, what's the significance? More often than not, it relates to the type of compensation available, hence that being the significance. FIDIC, for example, allows for time and cost for political type events, but only extension of time for natural FM events. On the other hand, if the clause has been amended to reflect a third party's FM clause, then relief may be subject to further limits, caveats, or monetary thresholds. Again, the message here is what we learned from reviewing it is not to assume that the treatment of FM under a primary contract is mirrored exactly into the EPC contract and vice versa. I think at this point it's worth also looking at change in law. Although that's not mentioned specifically in FIDIC, often in clauses in EPC contracts that have been amended to match provisions in the primary or head contract to specify that change in law qualifies as a political FM event. Again, what's the significance of this? Taking the recent example of COVID-19 based claims, often the claim can centre on emergency legislation or decrees that have been passed that prevent or restrict the movement of people and goods. It's important at this point to examine whether this qualifies as a change in law political FM based on the extent of the legislative changes and whether the associated relief differs between force majeure and change in law, or whether it actually subset the same thing. The third question there is there a causal link between the FM event in question and an impact on a party's ability to perform? This point quickly becomes the focus for discussions about FM, or more accurately, the affected party's entitlement to FM protection. Assuming that the parties have established that an FM event has actually occurred, then the onus will be on the party claiming relief to evidence that there is a chain of events linking the event and the ability of the party to perform its obligations under the contract. At this stage, it's worth remembering that where pre-existing delays occurred in the activities of a claiming party, then these need to be separated from the analysis of an FM claim. Again, although the wording of each FM clause may differ, it's a common thread that any party wishing to benefit from the protection of FM provisions must establish to the requisite standard how and why the event is actually preventing performance. We've experienced recent claims where contractors or affected parties have been able to only highlight high-level links between the event and the relief claimed. COVID here probably provides a very useful example where some parties and claims have submitted what can be termed as vague links along the lines of COVID-19 is preventing me from obtaining goods and supplies from my supply chain. These types of statements often can be insufficient to meet the requirements of the contract itself and likely to give rise to just further requests for particulars from the counterparty, which in itself can lead to further potential disruptions and delays. We'll come back to this point in a bit more detail. And the final one there is what has actually been agreed as the consequences if an FM event occurs. Does it entirely excuse parties from their obligations under the contract or cause such obligations to be suspended until the event subsides? Does it give rise to a right to terminate after a passage of a certain period of time? And as we mentioned before, does it give rise to cost and time or just time? Some construction contracts, including those using FIDIC Silver as their base, will allow largely only for an extension of time commensurate with the impact of the event itself. However, given our earlier point that FM clauses in construction contracts are often amended to take into account the FM provisions of third-party contracts such as PPAs and implementation agreements, it's not a given that the classic FIDIC position, time and cost will apply. Quite often we see the FM clauses that are passed down into construction contracts allow solely for an extension of time. This is often mitigated in the third-party contract with perhaps an extension to the term of the concession period, so as to allow the employer or the developers to earn out the value of any costs that have been incurred as a result of an FM event. Accordingly, this won't be passed down to the construction contractor as it doesn't match the risk of payment profile of the construction contract. In this case, there may be a situation where you have differing schemes for compensation between the third-party contract and the construction contract itself, and the interaction between the two will need to be analysed very carefully. A slight wrinkle to this being whether the concept of equivalent project relief exists, but again we'll return to that a little later in the talk. At this point, I'll hand over to Luke, who will talk further about some of the practical aspects related to FM and associated issues. Over to you, Luke.
Thanks, Talvinder. So, having looked at some of the requirements to satisfy a typical FM provision, I'm going to spend a bit of time looking at some of the practicalities of making and responding to FM claims under construction contracts. I'll start to begin with the format really of the FM claim. As we've been saying, each contract is different. The claim process can vary from contract to contract. So again, the mantra is read your contract. You should consider whether there are any time limits for the FM claim under the contract. Construction contracts often contain language that state that a notice of FM must be given within a certain time period. Now that might range, we see anywhere between 5 days to 28 days sometimes. And you should check what that contract says about when the clock starts ticking on that time period. At the very least, it will begin when the affected party is actually aware of the FM event. But in a number of clauses we see, there is also a concept of deemed knowledge of the occurrence of the FM event. So the time period for giving the notice actually starts when the affected party should have become aware of the FM. The question that then often comes up about these time limits is whether they act as a time bar, i.e. the affected party loses the rights arising from the FM if it fails to submit its claim on time. Now, typically English courts are reluctant to interpret requirements as to form and time limits too strictly. But however, if there is express wording that a claim within the time period is a condition precedent to the FM entitlement, then it's likely that that would be given effect by a court or a tribunal, and therefore the contractor's rights would be lost if it doesn't comply with that requirement. Now, that kind of wording is frequently found in the claims requirements of the FIDIC contracts, for those of you that know it, at the back end around clause 20. And in the context of COVID, returning again to that as an example, this has often resulted in EPC contractors submitting initial notices of claim of FM in relation to COVID, but with very little in the way of detail. They're doing so just to ensure that they don't lose their rights, albeit that the claim itself is not particularly detailed at that point in time. And that leads me to the next point there on the slides, which is what form, if any, does the contractual notice need to take? Now, actually, it's rare that a construction contract requires a set form of notice or a template, but you should nonetheless check. But broadly, that would leave a contractor free to submit its FM notice in whatever form it sees fit. Now, it shouldn't be forgotten that the claim nonetheless needs to respect any other requirements for contractual notices. So it needs to be sent to the correct address. It needs to be submitted in the manner specified in the notices section of the contract, that much forgotten section, boilerplate as it is. But it's worth mentioning that renewed focus is obviously now on that section. So is notice provided for by submission of an email? Not a lot of contracts provide for electronic notices. Do they provide for fax? Lots of people still put a fax number in the notices section, but actually that raises the question of really how many businesses are using fax these days. And then what will be really important is the level of detail required to be contained within the notice, which brings me to my next point. I'll start by referring to that standard wording of FIDIC, which requires a fully detailed claim, which includes full supporting particulars of the basis of the claim. And other EPC contracts are likely to include something quite similar. Now, there could be differing interpretations of what a fully detailed claim looks like, but certainly it would be difficult for the recipient of an FM claim to assess that claim without a good level of detail. Now, that might seem obvious, but as I mentioned, during COVID, we have seen a number of contractors submit claims with really quite vague particulars as to the way in which they have been impacted by COVID, making generic references to disruption to supply chains and the ability of personnel to attend site. But without greater details setting out what supplies and where and how, which personnel, how long, whether local personnel could have been deployed, there is not really going to be enough on which anyone can base a genuine assessment of the FM claim. And the tricky position then that project companies may find themselves in is balancing a need to correctly administer the clauses of the EPC contract and administer the claim with a claim in front of them that is in fact light on detail. Which brings me to the next slide, in which we'll talk about supporting documentation. Arvinder mentioned this a little bit earlier, but it's worth remembering that an FM claim is still just a claim like any other. Entitlements turn on the facts of each case. That makes it particularly important to keep good records as to the event itself, records also as to the impacts. So questions that you need to be asking yourself are, what happened during the event to make it an FM, and what evidence is there? Even if the event is considered an FM, what activities were affected and what's the evidence of that? How were they affected? What are the delays? What has that done to the construction schedule? What critical path analysis is being done to demonstrate delay? And in the case of extension of time claims, good critical path analysis can be extremely important. Clearly, the more contemporaneous it is, the better. Really, all of these questions and reminders go to the question of causation. Did the FM event actually have the impacts that are being claimed, and therefore does the contractor get the relief it's seeking? The documentary evidence that might be provided might be formal correspondence in the form of letters, maybe emails, there may be minutes of site meetings. And the parties should make sure in particular that they are accurate So if a set of minutes of meetings is provided and somebody disagrees with the facts summarised in that minutes of meeting, they should be questioned and corrected contemporaneously. So really the final point on the slide is to remember again that the onus is on the party claiming the relief to make out its claim. It must demonstrate the FM requirements are satisfied, and it must demonstrate with evidence that the FM event had the impact complained of. Moving then on to the next aspect we wanted to talk about, which is the obligation on the affected party to mitigate the impact of the FM event. Now, often in FM clauses, there is both a prospective and a retrospective element to that obligation, both a requirement to have sought to prevent the event having an impact, but also to reduce its impact once the event has happened. In a construction context, that could mean taking steps such as making adjustments to your supply chain, resequencing work activities, implementing business continuity plans of the sort that companies generally keep in place for major incidents. The mitigation obligation is generally one that requires reasonable steps to be taken. Affected parties do need to make some effort, and that's likely to include incurring a certain amount of cost, although it generally won't mean going to the ends of the earth. The obligation is also an ongoing one. It does not stop, and the party can't sit on its hands in the wake of the FM event. So if workable measures can be implemented to enable construction and design work to continue, then they should be taken. In the context again of COVID, measures such as PPE, on-site testing, social distancing, limited quarantine and such like may well be available mitigation, which means they could preclude or at least reduce the relief available to the contractor. And that leads me to just touch upon a question likely to come around in the months to come, which is the prospect of second waves of COVID. For example, we've seen new lockdowns imposed in various countries such as Australia. Now, whether a second wave is actually a fresh FM event or a continuation of the first event might need further consideration. I suspect that cautious approach will probably be taken by affected parties who will notify again as if it were a new event of force majeure. Now, to what extent FM claims will be satisfied again in that second wave will be a question that needs to be held up against the circumstances at the time. Sort of questions we expect will need to be looked at are: what were reasonable measures to prevent or mitigate the impact of a second wave? Could the affected party implement mitigation measures faster, more effectively than with the first wave? In fact, are measures that were already implemented in the first wave of COVID enough? Could more be done in advance of or in response to a second wave? And are the impacts in fact the same? Are travel restrictions going to be different in a second wave? Are different activities going to be impacted compared to the first time around? So in general, we'd say that where it looks like lessons have not been learned from the first wave of COVID, new FM claims relating to a second wave are going to have less chance of success. And I wanted to touch on, before we move on from that slide, we couldn't let a session on FM pass without a mention of the significance of pass-through or back-to-back of force majeure. In many projects, it is key that the FM entitlements of an EPC contractor align with those of the project company. And that's usually achieved within the wording of the EPC contract by mirroring the wording so there is no mismatch in the terms of the relief itself. Now, in some sectors, in some countries, EPC contracts might typically also feature what we call equivalent relief or equivalent project relief wording. Now, the purpose of those clauses is to make the relief at the EPC level dependent and contingent upon equivalent relief being granted to the project at the level of the head contract, PPA or the concession agreement. Now, to the extent a claim for FM is made under a construction contract which is dependent on relief from the other contract, then the timing and impact of those should be factored in. As we've been saying, the specific wording of your contract is going to be key. The language will often limit the relief available or create additional steps on the parties before the relevant relief can be passed down from the main agreement. And equally, there may be exceptions to that pass-through principle that you need to be aware of when operating such clauses. Next slide. So we're going to end on some political and strategic considerations relating to FM claims. Project companies who receive FM claims do need to make sure they comply with the EPC contract in responding to the claim. It's generally not well received in dispute proceedings if in fact claims are not adequately administered, because especially in construction circles, there's a very real focus on being seen to avoid disputes, and dealing promptly with contractor claims is a key aspect of that. When sending FM claims, you need to consider how your notice might be received by a counterparty. And in relation to that, we just want to step out from beyond the construction focus of this session and mention that FM claims made up the chain to utilities or host governments might not be met with the same response as more sophisticated party familiar with these sorts of processes. They may not be used to working with complex contracts and administering legal notices, so the receipt of a very legalistic document making claims could cause quite a shock. This is particularly so where the basis for the FM claim is political FM or change in law. And albeit that the relevant PPA or concession agreement provides for the protections being notified in the claim, we have seen governments surprised to receive FM notices from their private sector partners, and these can be emotive issues. So our message here is really that it's important to consider starting a dialogue to broach the matter in an efficient but politically sensitive manner. It might be worthwhile informally conveying the intention to claim FM, giving relevant background prior to a formal notice in order to sensitise the relevant officials. However, and notwithstanding that sort of informal approach, the affected party really should not neglect to send a notice if it is required within a specific time limit in order to preserve rights. So that brings us to the end of the formal presentation part of the session. Clearly FM is an area under close scrutiny right now, possibly more so than ever before. It's also an area where the specifics of your contract are particularly important. On that note, could I perhaps ask Fiona to let us know what's been coming through on the Q&A, and we'll try to deal with as much as we can.
Thank you very much, both Luke and Harvinder. So thank you all for sending contracts. Predictably, a number of the questions we've had, which we will tackle first, do relate to the very current issue of COVID. So if I can hand over to Harvinder in a moment. The question we have is, I hadn't predicted, no one could have predicted COVID-19. My contract doesn't mention COVID-19 or even relate to it, to a pandemic. Does this mean that I can't claim force majeure? Harvinder, would you be able to take that question?
Thanks, Fiona. Thanks, Fiona. Yeah, it's quite a common question. We're seeing this one more and more. I think the absence of an express mention to COVID isn't necessarily fatal, insofar as I don't think before the current crisis anyone would probably know what COVID actually was. But I think it comes back to the wording of the contract. For example, if the contract itself does actually describe an event similar to COVID, then that can be an important factor there. But again, we would wind back to where we were earlier in the talk, where we mentioned that it's important to look at what the test for force majeure is. If the test for force majeure, it has to be an event which is beyond the reasonable control of the parties, couldn't have been avoided, is not attributable to the other party. If it's that kind of test, then whether or not the contract specifically states COVID-19 or even epidemic may not be so much of an issue. If, on the other hand, the contract you're dealing with may actually gives a closed list of events that are deemed to be force majeure, then it may be a little more problematic. But again, I think it's not immediately fatal if COVID isn't mentioned, but it will come back down to what the test of FM is in that given contract.
Thank you very much, Harvinder. And moving across to Luke, the next question we have had, and I think it's probably one that had worried a number of clients. We mention in our contracts epidemic, but we have never made reference to pandemic. Obviously, COVID-19 is being referred to as a pandemic. Can I claim under the epidemic wording in my existing EPC contracts?
Thanks, Fiona. I think, generally speaking, there's been a coalescing of views amongst many of the lawyer community around this. Generally speaking, you'll look to the ordinary meaning of the words in your contract, absent any other definition that they've been provided with. And at that point in time, I think the fact that the WHO has declared COVID a pandemic, has described pandemics as epidemics that have a wider geographical reach. Describe pandemics as being epidemics that have a wider geographical reach. I think has meant that in reality, a force majeure clause where, as Harv mentioned, if you satisfy all the general tests and there's a specific mention of epidemic, there's not really going to be much problem saying, yes, a pandemic is caught within that clause.
Thank you, Luke. Another question we've had through from the audience, and I think this is, obviously there is a prevalence in the market that EPC contracts are governed by English law. It's not unusual then that your underlying concession contract or whatever the contract above is, it may well not be governed by English law. So the question we've had is, how do you really manage this risk between, for example, a concession agreement that may be governed under a civil code and a civil law system with trying to pass through rights to an EPC contract which is governed by English law?
Thanks, Fiona. Yes, that's something that we at Trinity, we see that somewhat frequently actually in a number of our Francophone transactions where, as you say, the local law is a codified, a civil law jurisdiction, but your underlying subcontracts at EPC and O&M level have been undertaken under English law, generally speaking, to sort of attract as many bidders and tenderers as possible to the work. Your first port of call would always be to try and make sure that your pass-through, your drafting pass-through and flow down is as close as possible to your definitions within your civil law concession agreement, including the codified aspects. You want to pay close attention to making sure that even if there are aspects of the civil code rather, definition of force majeure that are not captured by your concession agreement, but that would nonetheless apply, you are flowing those down to your English law EPC or O&M. And it's because under English law, your force majeure concept is a purely contractual mechanism that you can do that. So as long as you're doing it well enough in advance, you're making sure that you're presenting it to your contractors early in the process, preferably in a formal contract that's gone out to a series of bidders, then actually your contractors know what they're dealing with, they know what they're bidding to, and either they've accepted it when they make their bid, or you know what their objections might be if they've provided some sort of markup of that document when they made their bid.
Thank you, Luke. So thank you both very much. It's clear that this is, as I mentioned earlier, this is clearly a very current topic with the current COVID crisis. And I think it was particularly useful examining potential mitigants and what may happen if there is a second round and how that may be treated under the force majeure provisions. So again, thank you. I think that's about all we've got time for today's Trinity Talk sessions. So again, I extend my thanks to London partner Luke Muchamore and London Council Harvinder Diol for speaking to us today. If you have any further questions about EPC contracts, or in particular the force majeure provision, you know where to find us, so please just drop any of the team an email and we'll try and help you. Next week we will be back, and again we will be examining the World Bank partial risk guarantee. So I do hope that you've enjoyed today's session, and I very much hope that we will see you again next week. Many thanks.